South Carolina's family court system is undergoing the most aggressive reform push in its history, and fewer attorneys have a clearer view of what's broken, what needs to change than attorney Lauren Taylor, who's worked inside the system for more than a decade. So as this push for reform gains momentum, um, they are proposing a rebuttable presumption of 50-50 custody, new accountability measures for guardians ad litem, and written justification for when judges award anything less than 50-50 custody. So Lauren's here today to help us break down what these reforms would actually mean for families, children, and the lawyers to navigate the system on a daily basis. So Lauren, first of all, what was your initial reaction when you saw this proposed reform plan?
Hi, Jen. Thank you so much for having me on. So, yeah, my initial reaction was one of shock, honestly. I think everyone that works inside of the family court system in the state would absolutely tell you that we are in need of desperate reform in many areas. However, I understand the thought process behind this, and I think really it goes to a more equitable push towards fathers. Our state has always, I have to kind of deal with this a lot when people come into my office. They seem to think there's like this rebuttable presumption of a mother is more fit for custody, or something that South Carolina used to hold on to for a long time, which was called the tender years doctrine, meaning like children that are, still breastfeeding or under a certain age might need their mother more than they need their father. So I think our state has a long history of maybe prioritizing mothers in custody situations, and this bill is an effort to try to even the playing field between both parties. Now, however, what sounds good in theory will undoubtedly have massive implications, once it's actually applied. So one of the big things that I think is an issue here is the presumption that 50-50 custody is going to be the norm. Okay, let's start with that. So first things first, in normal, healthy, safe homes, absolutely is it imperative for the children to have both parents participate in their life, in their rearing, and in their upbringing. Right now, South Carolina follows what we call the best interest of the child, which means we don't care whose parent is doing what. We only are focused on what that child needs to thrive and be as successful as possible. So that's a really good baseline, right? When we're concerned with taking care of our youth and our children. Now, what this is going to do is, number one, I think it's going to make divorces more costly, even though a lot of the supporters of this bill argue the opposite, that it will not make divorces more costly. Well, let me just give you an example. A lot of people, like I said, have wonderful, healthy homes, and even though they might not stay married, they both have a vested interest in their children's upbringing and the best interest of that child. However, unfortunately, more than we would like to admit, a lot of people do not have that safe and loving home environment. And just by the nature of things that happen in your personal home, it's much more difficult to prove those things, which is what this law is requiring, litigants to do if they want to deviate from that 50-50 custody. So an example would be, let's say that, there's some sort of abuse or alcoholism or drug abuse happening in your home. Those things could have previously been entered into through affidavits of other parties, photographic evidence, things like that. Now we're going to ask these judges to make a finding of fact at a temporary hearing based on this evidence. One, that evidence is extremely difficult to get just by the personal nature of it happens behind closed doors. And two, seeking that evidence is going to make the litigant who is asking for this deviation have to spend so much more money just to get to the same starting place that they would have been before. So that's the first thing is just, as much as we would love to live in a world where every parent is a great parent and can put in that 50-50 effort, that's not realistic. Now, let's pivot to the actual day to day of what life would look like for a child who went 50-50. Our state is geographically relatively small, considering a lot of other states in our country. But, from Myrtle Beach to Greenville, we're still looking at a 5, sometimes 5.5 hour drive, depending on traffic. What is the real life implication of that going to be for a child that is spending 1 week in one school and another week in another school? I myself was a child of divorced parents, and while my mother happened to live all the way in Hawaii and my dad lived in South Carolina, just the traveling, and you forget something at a parent's house, or your favorite lovey is at the other parent's house, you don't know where your homework is. It's already an unstable environment. Now, if we wanted to deviate from that to something that's a little bit more progressive, there is something called nesting, and that is where the children stay in the home and the parents are the ones who come and go. And that typically provides the least amount of disruption for the child. Now, most adults don't love the idea of having to share a space with their now ex spouse, or having their belongings be in a place where their ex spouse might be able to see them. So, these are all things that we really have to ask ourselves. So, we've already gone through, just the cost and the danger that's going to be associated with this presumption being put on judges.
Right.
The next thing is going to be the guardian ad litem. I can't tell you how many times I have clients that come to me and complain that the guardian isn't fair, or the guardian isn't listening to some of their complaints. And while there have been a few that I've dealt with over my 14 years of practice that have truly maybe not been doing the job that they should be doing, overall these guardians are, for the most part, they're lawyers, and they're getting paid at a reduced rate that they would be doing if they were the lawyer on the case. And a lot of times being a guardian forces you to be conflicted out, obviously, from being able to represent either party. This law is going to put so many things on guardians' plates. Something that's been addressed is that litigants can simply request a new guardian ad litem. They can ask their guardian ad litem to submit to drug and alcohol testing. The overall, opinion of a guardian, I think, is going to be valued less. So now we have
When
a. Sorry, go ahead.
for people that aren't familiar with the family court system, when is a guardian ad litem brought into a case?
Absolutely. So, anytime that you do not agree on a custody situation or a visitation situation, that is when a guardian ad litem is appointed. And typically, the fees are shared between both parties. Now,
Okay.
there's reasons that you can deviate from those fees, like if one parent, is in prison or is incarcerated or has done something that really shifts the scales in the other parent's favor. But the guardian's job is to be the lawyer for the child. So things that they do that good lawyers should ask guardians to do are conduct interviews with the parents, obviously, the teachers of the children, any coaches, anybody, any therapists, doctors, counselors. So they need to get a full 360 view of what is going on in these children's lives. They also meet with the children, and they really try to set up a safe space so that the children feel comfortable sharing what's going on. A lot of times, whether we have the best intentions or not, parents still, put a little bit of breadcrumbing in there to say, well, make sure you go tell the guardian how much fun you had this weekend at mom's or dad's house. And the guardian's job is to sift through that while protecting the child. And it's not easy being a guardian. If you put up a report to a judge that is unfavorable to another parent, you're doing it, you're doing something that is going to hurt them, and they're not always going to be happy about it. So I think in this state we have some really amazing guardian ad litems, and it would be such a travesty if we created legislation that either shooed them away from doing this work or tied their hands in a way where they couldn't meaningfully do it.
Right. That makes perfect sense. I mean, now in this bill, the presumption immediately ends if there's a domestic violence order. That's not, do you not believe that that is enough protection?
I don't believe that that's enough protection. A lot of times, when I started in the criminal sector, which really led into family law, because a lot of, CDVs or criminal domestic violence will, naturally lead to a divorce afterwards. But those situations are so volatile, they're so sensitive. Sometimes they take place in front of the children, which is very alarming to the family court, but sometimes they don't. And in a true, scary, abusive situation, I can't tell you how many times that the abused party doesn't have proof, or they were too scared to go to the hospital, or they were too scared to call the police, because the most dangerous time for an abused spouse to leave is when they make that report and when they tell the world, hey, this is what's happening inside my home and I'm not safe here anymore. So to just think that everyone is going to make that report, I think we all know better than that.
That makes perfect sense. So the 50-50, like establishing 50-50 as the default, would that reduce the power and subjectivity of the guardian ad litem recommendations, or does it simply shift that?
I think it's shifting the burden a little bit. So, what the guardian's recommendations are going to be, I think, are going to be sidestepped unless that guardian is able to find that proof throughout her investigation. And I don't know that we can really ask a guardian to do that kind of labor in this when really we want to keep their best interest in protecting the children. So, asking them to go on a fact finding mission to help present this case that would refute the 50-50, I think that burden is too great to put on them.
Okay. So there's a difference between private guardian ad litems and public guardian ad litems. What is the difference between those two?
So there's a lot of different programs in this state. You actually do not have to have a law degree to be a guardian ad litem. You also don't have to have a law degree to be a magistrate in this state, which I think we've heard enough about in other stories. But for the most part, I think we have long gone the way of doing, the non-attorney guardians. Now, sometimes those are really helpful for maybe lower income people or people that don't have as many disputed issues, but they still want a guardian to maybe just double check some things that are going on with the school or something. But overall, I find it to be a best practice to always have a guardian that has a law degree, just because they understand the consequences of some of the things that they can put in this report. And they're also more amenable to, the situational logic that is at play here. And they go in front of these judges time and time again. And the guardians have built rapport with these judges. The judges have to see the lawyers differently from the litigants. And I think that's something a lot of people, when they have a complaint about a guardian, they don't think that, okay, well, this judge isn't going to take as much, prudence with your complaint because they've worked with this guardian for 15 years and they've only ever seen, great work from them. So that is just going to make their job so much harder. And like I said, my biggest concern if this bill is put into law is that we're going to lose so many of the wonderful guardian ad litems that we have. And we're already really getting close to a shortage as it is. Like the best ones in the state are overburdened because lawyers want them. They know that they do a great job for their clients. So that's my biggest concern, along with the safety of the litigants and the children.
Right. I think one of the biggest things I've heard in terms of the need for this reform is that the current system is creating unequal outcomes based on money, availability, relationships. Do you see that ever? Or, I mean, is that a problem that you run into?
Oh, absolutely. Our standard visitation in this state right now is every other weekend and one day, in the corresponding off weeks. I think any parent that is used to being a face in front of their children every day is going to find that alarming, to go to 7 to 10 days a month versus seeing them every day. But, family court is not a math equation. We have parents, no matter what laws are litigated, they're going to be people that try to outsmart the system, right? I have sometimes parents that say, I want 50-50 custody because they know that it's going to reduce their child support obligation. However, they will never exercise that 50-50 custody right. They never show up, they never do anything. They're just on paper a co-parent and a joint custodian. So I think that, we're never going to create a bill that is perfect when we're dealing with imperfect people and people that don't always act in the best interest of their children. children. But I think putting as many precautionary steps in place, because one person falling victim to this court system and one kid being left with a parent that they shouldn't be left with, and tragedy is going to be what we're coming back from. And we're going to have a lot of what should we have done or why didn't we see this then? So I think all of these legislators have had at least some taste of family court and they understand what's at stake here. So I would encourage them just to spend a little bit more time thinking about the issues that are inevitably going to come up from the bill as it's currently written, and see if we can maybe put some things in that allow that to be more standard. But maybe if a parent doesn't exercise that right, then they lose it. And it doesn't just, because children get so upset when they think that they're having time with a parent and that parent doesn't execute that time. And then that leaves the other parent having to explain. And, they never want to disparage the other parent, but that's a difficult thing to do. So I think that would be a great adjustment is sure, if you want to have a 50-50 presumption and you want to lower your child support obligation, you
Right.
better be using every minute of that time.
That's a really I like that. That's a really interesting perspective. This is I mean, I've never been through family court. I mean, it's just not something that I've been through. And it's just like they're all things that somebody who hasn't experienced, I wouldn't have thought of. So this is really interesting. Are there parts of this proposed reform that you think could be beneficial if put in place the right way?
I mean, absolutely. I think in theory, like I said at the beginning of this interview, that it's great that we want to have a presumption that both parents want and are capable of co-parenting.
Right.
But I think, things just get sticky in the sauce and we can't blanket everyone as being this great, perfect parent because unfortunately, I think all of us have, someone we know or someone that's in our family that just doesn't fit that description.
Right. Yeah, that makes perfect sense. So as this moves forward, I think you've given some really interesting things to think about, as we look at judicial reform. And I do see, I hear from parents all the time that are just stuck in the system and don't have a way out. But these are really interesting perspectives and I really appreciate you sharing them. Is there anything else that you can think of that as we look at this?
Maybe just one more shout out for the legislators. If you want to save some time and some resources, why don't we abolish having to live separate and apart for 1 year?
Oh, that is a really good one.
Because
So,
that's the one that really gets people going and costs them a ton of money because they have to have a
right,
separate residence. And even, down here in Charleston, there's a lot of people that have what's called like a frog or, another dwelling unit that's still attached to their house. And you have judges saying, no, that's not good enough. Go get another apartment. And, so yeah, if you want to start and make a really good first step, I think that's the first thing we should come at.
oh, I like that. All right. Well, thank you so much for sitting down and talking to us. This has really been insightful for me, and hopefully it will be for our audience as well as we look at judicial reform. I mean, family courts it's one of the court systems that most people have had experience with. So I think it's good to get perspective from an actual attorney who is working within it on these proposed legislative reforms.
That's right. And it's important to note that family court, well, there's so many different types of lawyers and there's so many different types of laws. Like my personal opinion is that family court goes to the heart of people's lives. You're dealing with their livelihoods, their finances, their children, their homes, their retirement accounts. So nothing is as more personal to these people as this area of law. So it really does require legislative attention.
Right. And it affects daily. Like it's your day-to-day life. It's how you live, it's how you raise your kids. And yeah, I mean, I totally agree. Thank you so much once again.
Of course, Jen. Thank you.